With the economic disruption of COVID-19, America is facing a historic wave of bankruptcies. Today we'll take a look at a new trend in bankruptcy that is sometimes referred to as mothballing. Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're joined remotely by Rachel Albanese, a bankruptcy partner at the global law firm DLA Piper. Rachel, welcome to Talks on Law.
Thanks, Joel. It's a pleasure to be here.
Before we jump into mothballing, maybe you can give us a quick overview. What are you seeing in terms of bankruptcy trends today?
2020 has seen an unprecedented number of bankruptcy filings, not just really large companies, but also across industries. We've seen cases in oil and gas, healthcare, restaurants, and particularly retail, which is where we're seeing the mothballing phenomenon.
What exactly do you mean by mothballing?
Mothballing is essentially a pause in a Chapter 11 case. Ordinarily, when a debtor files Chapter 11, it's required to pay all of its operating expenses post-petition, which is the period following the bankruptcy filing. When a debtor files a motion for what we call mothballing relief, it's seeking to put its case into suspension.
They're getting a timeout. And is that period indefinite, or are we talking about a number of weeks or months?
Courts will grant mothballing for a certain period of time. It's not indefinite. In certain cases, they've granted relief for 30, 60, 90 days, and then upon expiration of that initial period, debtors can seek to extend it for some limited duration.
When it comes to granting this type of relief, what's the basis, the legal basis that companies are relying on?
Bankruptcy courts, which are courts of equity, are entitled to grant this kind of relief under two sections of the Bankruptcy Code. One is Section 105A, which is a broad grant of equitable discretion, and Section 305A, which authorizes a bankruptcy court to suspend or dismiss a bankruptcy case in the interest of justice.
And it's that suspension that gives rise to the term mothballing?
Exactly. And bankruptcy courts will generally employ a totality of the circumstances test in determining whether the relief is appropriate. We've seen that bankruptcy courts have been willing to grant this kind of relief during the pandemic due to, particularly in retail cases, reduced foot traffic and uncertainty of outcome.
Can you share with us a couple of examples where you've seen mothballing in recent bankruptcies?
One of the earliest examples of mothballing relief was in the Modell Sporting Goods case, where the debtor was about to hold liquidation sales in its stores, but following the shutdown order was not able to do that because the stores were closed. Other cases in which mothballing orders have been entered are Pier 1, Craftworks, JCPenney's, and Brooks Brothers, although in the latter, they're effectively seeking the same relief, which is the debtor is not obligated for some period of time to pay rent.
You mentioned rent, which brings me to the question of who are the losers, I suppose, when it comes to mothballing. What are the other parties involved and how are they affected?
As you can imagine, creditors and landlords are not enthusiastic about mothballing. Landlords have been some of the most vocal objectors to this type of request. And that's because they feel like these kinds of orders put the risk of the case, and primarily the risk of the debtor becoming administratively insolvent, meaning unable to pay its operating expenses, on the backs of the landlords. The landlords are unable to relet the property while the debtor is using it, and they're prevented by the Bankruptcy Code and the automatic stay from looking for new tenants.
That's an important aspect of the mothballing, which is not only are the landlords not being paid, but they're also unable to evict a tenant who may or may not be able to pay in the future.
That's right, although the debtor is required to pay any rent or other expenses and costs that it has incurred post-petition when the mothballing period expires.
So to mothball does not mean to wipe these expenses from the balance sheet. It's just a hold or a stay on when it needs to be paid.
That's right.
If the mothballing doesn't actually expunge any debt obligations, what benefit does it really offer to the companies?
The filing of a bankruptcy case provides a debtor with necessary breathing room and space from its creditors' collection efforts. These mothballing procedures often will provide the debtor with extra breathing room during a period of great uncertainty.
And this strategy of mothballing, is this something that's been going on for a long period of time, or is this new to the post-COVID era?
It's new to the post-COVID era, but the bankruptcy code provisions that permit the courts to grant this kind of relief have been there, and it's just due to creative lawyering that it has come about.
And before we let you go, maybe we can get your insight on what you predict in terms of this trend. Are courts likely to continue to offer this type of relief going forward?
Let's hope that courts don't need to offer this kind of relief on a long-term basis. But as long as this COVID crisis continues, I think the bankruptcy courts will be willing to offer this kind of relief to debtors who need it.
Rachel Albanese, thank you for joining us today and explaining a bit about bankruptcy mothballing.
My pleasure, Joel. Thanks for having me.